Uh, Folks, let's do the darn thing. We will do it the same way we always do. Any questions, comments, concerns about any material we have covered thus far that you need clarification on before we jump right back into where we left off? And if you don't, that's okay too.
Are there going to be any code questions on the exam? Like, not so much building code, but like, because I know in a few of the quizzes, there have been references to like U.S. or like Title 12, or whatever it was.
Um, I get where you're going with that. In general, no. There's not going to be any questions that like directly reference like laws and rules by number, or the actual, classification. There is some when we get into some financing things, like you will have to know things like Regulation X and Regulation Z. But nothing like specific building codes or Title 12. There's some things, but not to that extent. So don't panic about that. Now, sometimes you will see it called both, right? Like it'll say like RESPA and Regulation X, or Fair Housing and Regulation B, or, they'll kind of double up, or sometimes they'll call it Article 12. But you're not going to have anything where you have to memorize to that extent. Don't panic. Yeah, good question. What else? Any other questions, comments, concerns? Anthony, don't look so excited to be here, okay? Like they just like the arm thing, okay? Like she just, I'm gonna rest my head right here. I'm gonna stare at this man until he just stops talking, right? That's what I'm gonna. It's like that. After all we've been through, it's like that. Was this day 5, and you gonna do me dirty like that, Anthony? That's right. Listen, I expect that kind of stuff from Brooks, but from you, okay, that's just breaking my heart here. Savannah, tell her it's unacceptable. Just tell her. Just be like, just shake it. Just no. Just don't do it. It's ruthless. There you go. Savannah's got my back. I kid. So let's jump back into it, folks. If y'all are feeling froggy, sure, why not? We have gotten into a very interesting part, and as I said, we're going to start moving a little bit faster, at a certain point tonight, and things kind of progress faster even after this section. It's just because these first kind of like 5 units, if you will, it's all such new material and new concepts to you, so it takes a while to build the foundational knowledge to help you understand the things that we're getting into right now. And once we kind of lay this foundation, it makes it a little bit easier to explain some of the later concepts, so the class does end up moving faster. The downside is these are the least testable chapters, but you really need them to build some foundational knowledge on some of the more testable chapters later on. So we're talking about encumbrances. And so we started discussing financial encumbrances versus physical encumbrances, and we're really in the financial side. And so the most prominent type of financial encumbrance is a lien. And I told you, when you see that word lien, it kind of sounds like loan. And it's because you owe money to somebody, and that person has the right to go after you or a property, depending, to try to get that money. If they're going after a person, it's called a general lien. If it's attaching to a specific piece of real estate or a specific piece of property, it's called a specific lien. And understand that when I say attached, right, I don't mean they like walk up to a house and tape it to the window, right? It's in the register of deed. Well, sometimes things are taped to the window, Brooks. I mean, sometimes. When we're talking about the register of deeds, and there's going to be a slide for this, but let me help you understand this. I kind of gave you a little bit of insight into this last night. The register of deeds is a record-keeping place. Every single county has their own register of deeds. And the register of deeds is a place. It is actually a room full of giant books where you go and you pay to have something recorded. And what that is making it public record. It is serving as constructive notice to the public that this thing exists, whether that be a transfer of ownership by way of a deed or somebody's right to go after the property by way of a lien. So these liens are actually attached to the property, so they show up in these title searches. And there can be more than one lien on a property. When we were talking about those specific liens, let me backtrack here for a second on these slides. If you look back, let's see, my clicker's working here. Let's see. Yeah. If you look back, we named some different ones, right? The deed of trust and or mortgage, depending on which state you are, which is a voluntary lien you put on their property when you borrow money to buy the house. But we said real property tax liens, special assessments liens, mechanics liens. All of these could exist on a property at one time. And so this is where we get into another interesting concept with the liens, folks. There is what we call lien priority. And so typically when we're dealing with liens being attached to a property, the default for liens is first come, first serve, right? If you were recorded first, you'd get paid first. I'm going to explain more in a second why that's important, why that matters. But let's just help you understand this in the easiest way possible. Let's say, folks, that there was 5 liens on the property and the property gets foreclosed upon, and the property is not sold at auction for enough to pay off all the liens. That means somebody's not getting their money. Because if there ain't no money, there's no money to give. And so I'm going to give you an example of this, but listen to me very carefully because people get a little confused on this. If I asked you which lien was paid out first, your default answer would be first come, first serve, except. Very, very important, very testable piece here. When we're dealing with real property tax liens and or special assessments liens, they have this special rule about them that says that they are going to get paid first above all other liens, regardless of when they were recorded. They have this special priority. Now, that's about liens. If I ask you what is the first thing that has to get paid in a foreclosure auction, it's not a lien, it's the cost of the foreclosure. Because if we're not facilitating the foreclosure, there's no money to divvy out. So let me just paint a picture for you, okay? Let's say that we had a property in North Carolina and they owed the bank $200,000. I'm just going to put 200K because I'm writing with a mouse and it's ridiculous. And let's say that that was recorded the day they bought the house. And we'll just say that it was today's date 10 years ago. So October 29th of 2014. 10 years ago. Lord have mercy. So it was recorded a very long time ago. Now let's say that somewhere along the line in 2020, they stopped paying their real property taxes. So they had a real property tax lien for 2020, 21, 22, and 23 that were outstanding. And let's just say that they were $10,000 each. So I'm going to put $40,000 that they owe for real property taxes. And just to make this example easy, I will say that, this lien was recorded on 2023, right? Just sometime in 2023. Well, we can all agree that this one was recorded against the property long after this one was. But this one's still going to be paid first, and you'll see why this is important. Now, mechanics liens, let's just say, and I'm going to explain these more in a second. Let's say that they're owed $30,000. They have a mechanics lien on there. I don't know why I picked $30,000 because now I've made the math weird, but it doesn't matter. So here's what happens. Let's say that they now stop paying the bank. They've been paying the bank on time, but today in 2024, they stopped paying the bank. And the bank forecloses on this property. I told you yesterday, a foreclosure is not the bank taking the property. The bank doesn't want it. The bank wants their money. So what a foreclosure is forcing the sale. So they're going to order somebody in North Carolina called the trustee to sell this home at auction at the county courthouse. And it will be an auction bid, and somebody will win. I'll get more into that in a second. But let's say that the person who wins this bid buys it for $250,000. Okay, well, the very first thing that of that $250,000 that somebody paid for this home, that's going to be paid is the cost of the foreclosure. So imagine that the cost of the foreclosure was $10,000. That means now we only have $240,000 left to divvy out. And even though this was recorded forever ago, I told you real property taxes and special assessments beat out everything else. If you had to compare the two, real property taxes are paid first, then special assessments. But if both aren't present, they beat out everything else. And so now, of that $240,000 that's left, they're going to go ahead and take out the $40,000 to pay the tax assessor. So that's going to be paid off, right? And now there's going to be $200,000 left. And the bank is owed $200,000, so now the bank is going to get the rest. And this mechanics lien is getting nothing. And so when you're dealing with this, that's why it's important to understand which priority lien you are, where you are in the hierarchy. Because if there's 4 or 5 liens and you're lien 4 or 5 and anybody was to ever foreclose, you may or may not get your money. So from a testable point of view, what gets paid first in general, the cost of the foreclosure. But what liens get paid first, real property taxes and special assessments. And then everything else would go in order of recordation. So if for some weird circumstance the mechanics lien was recorded before this one, it would get paid first, but we didn't do it that way. Does this make sense for everybody? Now, the mechanics liens do have one unique thing about them, and let me try to explain that. Okay, I told you a mechanics lien is when you have somebody do work to your property, like, oh, I'm sorry, Raphael, what you got before I ramble on?
Yeah, I'm sorry. It's just that it will be always in that order, or it can be changed.
Number 1 and number 2 will never change. Cost of the foreclosure will always be number 1. Real property taxes will always be number 2. Special assessments will always be number 3, if they're both present. And then after that, it's whichever is recorded first. It's just that mortgages are typically the first thing recorded because it's recorded when you buy the house. And then mechanics liens would typically come after you buy the house. So everything else is in order of recordation except for those special things I just said.
So 1, 2, and 3 is always, and then
whatever. Well, 1 and 2 is always, right? Real property taxes and special assessments you can kind of group together. I'm just telling you, like, if they were both present, real property tax would be paid first, then special assessments. But think about it this way. Cost of the foreclosure is number 1. Real property taxes and special assessments always number 2, regardless of when they were recorded. And then everything else, first come, first serve. If it was recorded on the property first, it will get paid first.
Okay, so 1 and 2 is no negotiable. Everything else can be whatever comes first.
Whatever comes first. Yep.
Got it.
There you go.
Thanks.
Bridge says, can the mechanics liens precipitate the foreclosure? Yes, they can. We're going to talk about that. So when we're dealing with mechanics liens, I told you, it is any contractor, right? A roofer, somebody who did a bathroom remodel, even people who have done painting or anything like that, they could put a lien on your property. Now, here's the way that this works, okay? When you're dealing with this, imagine that you had a contractor come and they start work on your house on March 1st. And I guess I can just do March 1st. Okay, either they start work on your house on March 1st, or they at least drop off materials to start the work. And then they don't actually start the work until March 15th. Okay, they drop off materials here. They start the work here. But folks, depending on how big the project is, sometimes these can take months. And so let's say you're doing a big bathroom remodel, and they don't actually finish the job until July 1st. They can't put the lien on your property until they've finished the work. And they have 120 days from the last day to put that lien on your property. So in other words, 120 days after July 1st to put a lien on your property. Typically, they'll give you 30 days to pay your invoice, and if you don't pay it, they will record this lien on your property. But here's the unique thing about it. Even though your lien will be recorded sometime July 1st up to 120 days after that, it backdates and it acts as if the lien was recorded on the day that materials were dropped off or that work was started. Why is that important? Imagine that somewhere in here, they got a second mortgage for $30,000. This one's going to be paid second. This one's going to be paid first, because this one would backdate to the day that materials were dropped off or work was started. That is the one unique thing about this one. It can't be recorded until it's finalized. You have 120 days after finalized, but it backdates to the day that materials were dropped off or work was started, whichever. Now, to answer Bridges' question, a mechanic's lien can force a foreclosure, but they only have up to 180 days after completing the work in order to force that foreclosure. This is not an additional 180 days. That is part of that initial 120. So it's basically an additional 60 days. Now, here's the last piece of this. Very often, the mechanic's lien is sitting at the lowest end of the totem pole of those other liens, and so they may or may not want to initiate a foreclosure, because if it doesn't sell for enough, they may not get their money. But regardless of whether they initiate the foreclosure or not, you still owe them the money. So let's say, 200 days has passed, they didn't foreclose on your property, they do not have the right to foreclose on your property anymore. But that lien will stay there until you pay it off. So this is another thing that prevents you from conveying clear title to the next person, because you're going to have to pay that mechanic's lien off in order to sell your house. So it doesn't fall off. It'll stay there, but they can't foreclose after 180 days has passed. So as I just stated with these, and just so you can see it visually, because I'm talking, but some of you like to see it, it acts as if it was recorded on the day that you first started work or materials were dropped off, whichever occurs first. Now, the other piece right here says a North Carolina lien agent must be appointed for anything over $30,000 within 15 days. Why is this important? Folks, think about it. When you're dealing with a personally owned property that you live in, you don't need a lien agent. Why? Because you live there. But this mechanic's liens also exist for new construction properties. So if a builder owns a piece of dirt and they're going to be subcontracting out $200,000, $300,000 worth of work to other contractors, all those contractors have a right to put a lien on the property. So they would need to assign a lien agent, so all these contractors knew how many liens had been recorded against the property, if any, so that they can make sure that they were in an appropriate place for that matter. So kind of a unique thing. What you got, Brooks?
So if the builder is selling their own house, which a lot of the larger ones do, correct? Are they obliged to, and they don't pay off all the liens, right? Does that lien get attached to the builder or to the home? Because the home is transferring owners, so who would be responsible to repay that lien?
Yeah, so common practice is all sellers, including builders, have to pay off these liens unless there's agreement to the contrary. And so what they require the sellers to do is sign what's called a lien affidavit. It's basically where the seller attests under penalty of law that, hey, there are no other liens on this property that, would have appeared after you've done your title search that I'm not disclosing to you. And that basically gives the buyers the right to go after the sellers if a lien pops up thereafter. That's a very common practice. They have to sign that lien affidavit. Yeah. That's a good question. Now, we talked about this already. This is just, some of these are just like supplemental little tidbits, and so this one got duplicated in here. We already talked about the homestead exemption. That's just those additional protections for, certain creditors under bankruptcy and or smaller creditors. Obviously not the bank that you borrowed money from to buy the house. They can go after your house, but we said additional protections for your primary residence for some creditors. That's all the homestead exemption was. Now, these next two here, this is like loosey-goosey vocab. Like, it's not going to be crazy. You really just need to know that both of these are an encumbrance. So a writ, which is kind of like a formal documentation, it's kind of Old English, writ of attachment, basically it is an encumbrance because there is a situation where somebody may be trying to conceal property, sell off property, hide property, or something like that, and a writ of attachment would prevent them from doing this. This could happen in bankruptcy hearings where they put a writ of attachment saying you can't try to sell off property before you file bankruptcy. This could also happen in divorces where like the husband or the wife's trying to like sell off all these real estates and businesses pretending they don't have them, so when the divorce goes through and things of that nature, it's basically just a legal attachment to a house that says you cannot try to conceal, sell, or dispose of this property while this is going on. Okay, it's called a writ of attachment, and of course it's an encumbrance because you can't sell it while this is in the works. Writ of attachment. The other one that I told you is kind of just like a loosey-goosey. You got to know what it is and that it is a type of encumbrance. It's another just vocab word. It's called lis pendens. Lis pendens. Yet again, a lot of Latin-based things in this class. Loosely translates to pending litigation. And so kind of similar, except you can sell a property that's subject to lis pendens, but you would potentially be taking title to it subject to the outcome of any lawsuit. So if there is a foreclosure proceeding being initiated, they would file lis pendens against the property, and it does two things. Notifies anybody who's interested in buying it that it is initiating the foreclosure proceedings, and it would also notify other debtors, creditors, should I say, that this foreclosure was happening, and if you have any liens that you need to put on the property, make sure you do it before it gets foreclosed upon. It's just pending litigation. It just attaches to the house, notifies the public that the property is subject to pending litigation. Lis pendens, pending litigation.
And this ensures that they still get paid even if the house is sold before it?
Oh, that's a good question. This doesn't ensure anything because, as you just saw in a foreclosure, sometimes people don't get paid. So let me introduce a very interesting concept. In that example I gave you a few moments ago with the mechanics lien and they got nothing, when you foreclose on a property, you extinguish all the liens against the property because we can all agree that most buyers do not want to purchase the property subject to somebody else's liens. So they all get removed from their property in a foreclosure auction. So what happens when somebody who's owed money doesn't get paid from their specific lien, they can actually go to court and file what's called a deficiency judgment. Hey, I had a specific lien, but I didn't get my money from that because there was not enough money to give. And so a deficiency judgment will then grant them a general lien, and they can actually go after the person as opposed to the property to get their money. The other thing that sometimes happens is sometimes these businesses, especially like big banks, when they don't get all their money, sometimes they will write it off as a loss for tax purposes. But when they do that, they would report it to the IRS as a loss. And if you were forgiven $40,000, it's going to look to the IRS like you made $40,000. So you would be potentially liable for paying taxes on that forgiven debt. So both could potentially happen. But this doesn't guarantee that they're getting paid. It's just, this is going to happen. So this is not the end of the discussion on liens. In fact, we're going to get way, way more in depth with liens later in the financing section. At that point, your brains will be able to wrap around it a little bit more. So let's kind of segue into the physical encumbrances, okay? And we've been talking about a lot, right? The restricted covenants. I can't have chickens. I can't, build a bar. I can't put a shed. I can't, whatever. And then some of the other ones that we mentioned as well were easements and encroachments. Well, let's start with easements, okay? You've all probably heard the term easements before, but there are two very testable types to be aware of. And you have to understand what an easement actually is. An easement is the right to use the property of another. Not own, but use. I can walk through your property. I can access this through your property, right? Its emphasis is your property. It's yours, but I have the right to use it. That is an easement. It is a non-possessory. Possession is owning. And so it is a non-possessory right to use the land of another. And the two main types of easements are called an easement appurtenant and an easement in gross. Well, folks, what does that word appurtenant mean?
Runs with the land.
Under the land.
Runs with the land. runs with the land. So when we're dealing with an easement appurtenant, think that word appurtenant, right? Runs with the land. Now, an easement in gross, a little more confusing, but we're going to start with the appurtenant easement, or the easement appurtenant. It's called both. So the appurtenant easement always deals with two adjacent pieces of property, right? This lot and that lot, this lot and that lot, right? Two touching pieces of property. And so there is always a lot that gives a benefit, and there's always a lot that gets the benefit. The one that gives the benefit is called the servient tenement, and the one that gets the benefit is called the dominant tenement. And the key piece is this easement is granted between lot 1 and lot 2, or lot A and lot B, whatever you want to call them, not people, the lots. Now, the other thing that you have to understand is it's not so straightforward that it only has to be two properties. Let me give you an example of what this looks like. If you, and I'll come back to this slide if you need to see it for a second, but I want to show you the picture here. Here is a prime example of an appurtenant easement. And so if you look at this red line, imagine that these are the lot lines. You've got lot 1, lot 2, lot 3. This driveway right here clearly belongs to lot 2, no doubt. But this appurtenant easement allows lot 3 and lot 1 to use the driveway of lot 2 to access their properties. So lot 2 would be the servient tenement, giving the benefit, and lot 1 and lot 3 would both be dominant tenements, the ones getting the benefit. Now, here's the key piece of why it's called an appurtenant easement. Okay, imagine that Barry owns this lot, and Genesis owns this lot, and let me pick a different letter. Lena owns this lot. When that's the structure, right, Barry has to let Lena and, what did I say, Gerald, is that who I said? My memory is that bad. Gerald, did I say your name? Nod for me. Yeah, okay, I was Gerald. We're going with Gerald. If it was somebody else, it was Genesis? I don't know. Lord have mercy. Listen, did I tell y'all I taught for 4 hours before I came to talk to y'all? Y'all gotta help me out. Yeah, whoever the G person is, okay? G, Barry has to let G drive through his lot. G, that's your nickname. And Barry has to let Lena drive through his lot. But if Lena goes out and sells her property to Ashley, Barry cannot change anything, right? Barry still has to let Ashley drive through his yard. That is why it's called an appurtenant easement. It has nothing to do with the people. It's whoever owns lot 3, whoever owns lot 1, whoever owns lot 2. And you have to understand why we call this an encumbrance. Remind me, what does the word encumbrance mean?
They run with the land.
Nope, that's appurtenance.
It's a burden.
It is a burden or a limitation in use. Well, folks, can we all agree that Barry is burdened? Because Barry, so long as he owns his property, has to let 2 other randos drive through his yard. Can we also agree that the 2 randos are also burdened because the only way to get to their yards is driving through somebody else's? So that's why this is considered an encumbrance. You would know that if you bought lot 2 forevermore, you will have to let random people drive through your yard, and when you buy lot 3 and lot 1, you will forever have to drive through somebody else's yard. Now, I know what you're probably thinking, because everybody's, why would anybody do this? There's a lot of reasons. Folks, sometimes developers will buy parcels of land like this, and the DOT, which is the Department of Transportation, will say, well, I understand you're trying to build 3 or 4 homes here, but that's a high traffic area and we can't allow 3 separate driveways. So you will have to make this work with 1 driveway. Sometimes the planning board will restrict it. And so what do? They will develop it just like this, and they make 1 shared driveway because that's the only way that the subdivision ordinances will approve it. The planning board will approve it. So that happens sometimes. What you got, Barry?
Hey Seth, I'm actually in the process of building on family land right now. And this is actually, it might be hard to see, but it's actually 3 different properties where we have the septic easements kind of drawn out on each lot. So, yeah, I mean, it was pretty important for that to work out with each property for it to work.
And that's the perfect example, Barry, because I gave you the example of the developer. The other most common time that this works, family properties. Because a lot of times family land will be owned and then they'll subdivide it and give it to people. But what they will do is they will have to create these easements between them so that there's clarification, no fighting, and that it's legally structured. But then what happens with that, and this happens a lot, sometimes even on family property, if somebody owns it with this easement, if they sell it to a random person, this random person still also gets to access it, use it, and otherwise. And that's exactly right. So it's either developers or people who own it who have created this to make property more valuable, usable, or whatever. Prime example, absolutely. Has it been a straightforward process, Barry, or has it been a pain in the tuchus?
A pain. It's because we've had to have power lines moved and all sorts of things, and it's a hurry and wait process with getting the health department out here.
Yeah, hurry and wait is the best way to put it. That's exactly right. Always listen. Here is my running motto, just so y'all can mentally prepare for when you get your licenses. It is never a dull day in real estate, ever. Even like personal real estate, let alone when you're dealing with everybody else's real estate too. Right? That's exactly right. What you got, Savannah?
So I have 2 questions, just because I want to make sure I'm understanding. So, like in this situation, the driveway falls on lot 2. So technically, that person owns that part of the driveway, but they have to let other people use it.
Correct.
And then in that as well, and I might just be going off topic.
Don't you do it.
There was
I'm kidding.
Damages or anything to that?
Yeah.
Or are they responsible for fixing it?
That always comes up when I'm teaching this. Here's the thing. Don't worry about that for the test, but in the real world, when this is typically created, there will be what's called a road maintenance or driveway maintenance agreement, where there may be that they have to contribute a certain amount of cost for repairs because they access it. And it would just depend on a lot of different things. So outside of the scope of this class, but it is definitely a consideration in the real world, because if they're using it and it gets damaged, it's not really fair that lot 2 just has to keep fixing it, especially if lot 3 buys like a monster truck and starts tearing it up, right? Yeah, I agree. It's a good question. Typically, we just got to get very, very clear and concise in our documents for that.
Gotcha.
Yeah, good question.
Thank you.
Yeah. So the key piece here, right? It's always between a property and a property. Okay. We're not naming people. This is between lots 2, lots 1, lots 3, right? Or lot 2 and lot 3 and lot 2 and lot 1. And so that's what makes it a pertinent. Always runs with the land. Whoever owns it gets to utilize it. What you got, Synthil?
Yeah, I say I got the lot 1, lot 2, lot 3 clear everything. But one thing, why you mentioned the B conventional easement? What does it mean? What do you mean? You maintain like conventional easement.
Oh, I see what you're saying. We're going to talk about this in a moment. But so in North Carolina, more often than not, these easements are granted by a reservation or an express grant by the developer. But what an easement by necessity is basically stating that imagine that the person right here, why do I not have a color there? Why is it? Hold on. Let me pick a different color that you can see. Imagine that, Synthil, you owned lot 2 and lot 1. And you decided that you wanted the money, and so you sold off lot 1 to somebody else for them to build a house. Because, hey, you didn't use that back of your yard. You'd already built your house here, and so you sell that to somebody, and they buy it. Now imagine that your driveway ends right here, and there's not a driveway all the way back, and that this, use green to kind of hide it here, that this doesn't exist, and this is just raw dirt. And so somebody buys lot 1 from you, and then they come up and they say, okay, well, Synthil, I'm coming to build my house. And you're like, no. You can't drive through my yard to go build a house. I'm not going to allow that. In North Carolina, you were not allowed to landlock somebody. So you sold it to them behind your lot, and they could go to the courts and get what's called an easement by necessity. And they would force the courts to make you give them an easement. Now, if you did it yourself, that would just be by express grant. You, as the owner of the land, aka the developer, would draft that in when you sold it, making the land more valuable. But if you were stupid and forgot or didn't do it, they could get one forced by necessity with the courts. Does that make sense? Now, the reason why this one is not called an easement by necessity, it's called a conventional easement. Folks, there's nothing stopping somebody from building a driveway here. It's just that for whatever reason or another, when it was developed, when it was subdivided, when it was whatever, they did it this way, maybe from the DOT. But it's not by necessity. This property is not landlocked. It has access to a public road. But it may be restricted for other reasons. Does that make sense? Yeah. So, appurtenant easement, you do need to know that language, right? Appurtenant meaning two properties, not people. And then, of course, the servient tenement, the one giving the benefit, and the dominant tenement, the one getting the benefit. Now, here's the big kicker. Now, folks, you gotta just take it with a grain of salt here, because there's not too many, like, super in-depth examples that I can give of an easement engrossed in action that you'll really make a whole lot of sense, because most people wouldn't do it. But an easement engrossed differs because it is between a property and a person. The appurtenant easement was property. This one's property and person. Now, I'm just going to paint a picture for you to help you understand this, and then I'll get into the more practical application of this. If I, we'll just try to make this work. If I owned a beach house right here, and imagine that the, road runs, like there's like a driveway over here, and I have the rights to come down this driveway. It really doesn't matter how I access the house, but imagine that there is no like public beach access or whatever you want to imagine. But there's a lot right behind here that runs on a public road. From this is a driveway, not beach access. The beach access is over here from my house. Okay, it's just my house having beach access. And imagine that I own this property. Here's the beach. And who have I not picked on? Araceli owns this house. If I liked Araceli enough, I could have a document created that allows Araceli, my back neighbor, to access the property or the beach through my property. That's a private beach access for my property, not a public one. And hers, she would have to go down the road to the public beach access to get to it. But for whatever reason, I like Araceli enough. I could record a document that says, Araceli, I like you enough, and I will forever give you permission to access the beach through my property. Okay, here's where things get a little bit different, though. Now, you have to understand, this is in writing, this is recorded, and I can't take it back. Is that something that most people want to do? No. So that's why you just got to kind of roll with me here. But imagine that Araceli has this easement engrossed to access the beach through my private beach access. And then Araceli sells the property to Raphael. When Raphael buys the house, that easement died because it was only given to Araceli. It was not given to that lot. See the difference? My lot gave the right to Araceli. And when Araceli moved away, she made it null and void. Raphael does not get to use it because it's between my property. Let's just call my property lot 1. This one's lot 2. It was not between lot 1 and lot 2. It was between lot 1 and Araceli. If Araceli died, it would also die. But let me show you the one weird thing here. Imagine instead of buying Araceli's property, I sell my property to Raphael. And when Raphael buys my property, he still has to let Araceli use it because it was between the property, which still exists, and a person. The property did not change. It was lot 1 granting this right to Araceli the person. If Araceli dies, if Araceli moves away, it would die. But me selling the property, it's still an encumbrance on the property. Raphael has to let Araceli keep using it. What you got, Raphael?
In this case, this is like some sort of verbal agreement.
Not verbal. We're going to talk about verbal in just a second. This one, and that's where you got to understand who in their right mind would do this and put it in writing where I couldn't take it back. Nobody. I mean, unless there was once again, maybe for family, maybe for somebody very specific, maybe. Is this common? No. I mean, there could be, family members. Let's go back to what Barry said. Barry just said something about septic easements. Sometimes family members will grant well rights, an easement engrossed to access or tie into a well. So let me just give you kind of that example. If I owned a property here, and my brother owned a property here, this is me, this is brother, and his well failed or was having issues, I may grant my brother a well easement that allows him to tie into my well. My brother has the right to tie into the well on that property. But it's because it's my brother that I'm okay with doing that. I'm not going to let some other random person who buys this property tie into my well. So it would be very specific, but we're talking about it's in writing and it's recorded, which means it's enforceable and you can't take it back. There's not a whole lot of circumstances where it would be common practice, but it would absolutely be an encumbrance because it sticks with that property. But if the person dies, it's dead. Does that make sense? What you got, Brooks?
So, I had a buddy a few months back. He bought some landlocked property that already had a driveway easement on it, right?
Yep.
But it didn't have any utilities going to it. It was technically within incorporated, so it was under sewer, and it needed power run to it, right? So, how do utility easements work? Do the landowners that are between the utility hookup and the home have to approve, or can they deny the easement request? Does that make sense?
Yeah, so he had access to the property, but there was no utilities running to it, and the utilities would have to run through the servient property to get to his property. Yeah. So that's kind of the interesting thing about these. That, I would argue, would fall into that easement by necessity because of utility of the use of the property. Now, unfortunately, I honestly can't give you like a very concrete answer. There are attorneys that specialize in, easements and rights and stuff. And typically, for legality purposes, I don't think the power company will just come out and do it. So what happens, just to put in perspective, folks, when a developer is building a neighborhood, they grant public right-of-way for, because they have to have a potentially a public road. But then aside from that, they also give all these power line and electrical easements to the utility companies. Why? Because what good is a house without water, electric, or internet? And so they will grant all these utilities to these different companies to access it. Now, the developer, yet again, gives them an express grant allowing that and forming that. To force somebody else's, that's a completely different ballgame. And so I don't really know exactly how that would work. I would imagine that you could force it, but I don't know if it's automatic or if that involves an attorney, right? Kind of a weird one. Now, that being said, that is the other most common time, and that's a little more understandable. These easements in gross, what we call a commercial easement in gross, is granted to a business like a power company, like a water company. This is the reason why they can come and fix your line in your yard. They can check your water meter. They could come check your electric. And then same thing, too, if you have power lines running behind your property, a lot of people will have power line easements. Now, those are between the property and the power company. And because businesses can be absorbed and or rebranded and stuff, they don't die the same way that, the individual one. So, yet again, recorded, they would exist in perpetuity. The commercial easements in gross are the most common easements in gross for, power utilities and things of that nature. So going back to what Synthil pointed out on that previous image, when we're dealing with creating an easement, I told you the most common way is the person who owns the property either creates it before they sell it, or they sell something and then reserve themselves an easement. So an express grant means that they would grant the right to another, the dominant tenement, and sell that off and give them the right to access theirs. Express reservation means they kept the dominant tenement and they gave themselves the access to it for one reason or another. Those are obviously voluntarily done. So let's go back to Barry's example. Family decided voluntarily to create certain easements by choice when they own it. I'll give you another example. I had some clients who owned 2 properties, really cool, in downtown Raleigh. And they were older, like built in like the 1920s, like bungalow style homes. And if you looked at the property line, it kind of went like this. And there was a driveway in between the 2 properties. It went like that. So half the driveway was on one lot, half the driveway was on the other lot. Now, there was no clear indication of that at the time that this was done or when they bought it. But the cool thing was they owned both. And so as the owner of both, they created what was called a road easement agreement. Basically, the owner of Lot A and the owner of Lot B could both access temporarily and use temporarily this driveway, but neither had the right to park there, neither had the right to do whatever. And so as the owner, aka the developer, it's just, why we call them that, you own it, you can do what you want with it by putting rules or whatever, they were able to make it a little more sellable. So when they sold off Lot A, they still own Lot B, and so that would be technically both fall into this category, but they basically gave themselves the right to still access it, even though they sold off Lot A. And then they eventually sold off Lot B, and it made it very clear and concise for the future owners. So very common that the developers just say, well, we need this power line easement, we need this access, we need this, shared driveway. But when I say developer, don't automatically think, oh, like commercial developer. Anybody who owns land and subdivide it can be called a developer, technically speaking. Now, the other ways that easements can be created, we were just talking with Synthel about the necessity. Okay, you have to be able to access your property, and there are some properties that exist that do not have access to a public road or public right-of-way. And so if you were to sell somebody that property and you didn't give them an easement by one of those other voluntary ways, they could go to court and force an easement by necessity. And for good reason, folks. What are you going to do with landlocked property? Jump out of a helicopter and rappel out like Batman every time you need to access it? Doesn't really make a whole lot of sense, does it? Brooks says, facts, absolutely I would.
No, actually, I was going back to that. You say that's a joke, but there's actually public land in the state of North Carolina. I think it's near Mebane. That's actually public hunting land with 0 easements, 0 roadways to get to it. And on their website it says only accessible by helicopter. So
I hope it's got some really good deer on it if I'm going to take a helicopter in there and a helicopter out.
I don't know, but I would be loving that if I was one of the adjacent landowners.
Yeah.
Free private hunting land.
Yeah, you just walk right in there. Only accessible by helicopter unless you live next to it. I'm just mosey on over and nobody else can get there. That's kind of dumb. I'm going to have to find this. The one in the middle, I'm going to skip over this for a second, and you'll see why, because it's a very confusing one. Let's talk about this one. Folks, in a minute, we're going to talk about ways that you could lose your property. And one of the ways is the government can take it by way of something called eminent domain. Now, don't focus on that yet, but this is a similar concept as eminent domain, except just like the government can take your property, they can also create easements on your property for their benefit or for the benefit of the public good, like gas lines running through your property or electric lines running through your property or fiber optic line. They can do whatever they want if it's for the public good. And so, yeah, it could be sidewalks as well. But they can even, like I said, do gas lines and water and all kinds of things. So you can create one as the government by force. Now, the act of taking the land is called condemnation. And so you can also create an easement by condemnation, right? Forcing the easement instead of forcing taking it. And that'll make more sense when I get into that section.